Welcome to the next edition of War Story Wednesdays. This is a case that kind of tickles me.
Tickle fast!
This has to do with a veteran real estate investor, somebody who's been buying and selling properties for 25 years, multiple pieces of property, who finally gets around to selling 2 apartment buildings and then buys 2 more. Except he did not buy and sell these under the Internal Revenue Code Section 1031, which allows for tax deferral of the profit that's been made on the sale of each of those 2 properties. So the client, unhappy at a $34,000 tax bill, decides that it has to be somebody else's fault and sues the real estate broker, claiming that the real estate broker had a duty to advise this investor about the opportunity to do a 1031 tax-deferred exchange. And then when the broker failed to recommend structuring the deal that way, the broker breached its duty to the client. Now, in a lot of these war stories, we hear about brokers that have done some pretty dumb things. And we hear about some clients who have been pretty, well, screwed over as a result. The court had no sympathy whatsoever for the 25-year investor who said the real estate broker should have told me about doing a tax-deferred exchange. Okay, they needed something to hang their hat on. What did they use? Well, the listing agreement with the broker said that the client was responsible for getting his own tax advice. And there's a civil code section that said that a seller is responsible for consulting a tax professional if you want tax advice. All of that's nice and it's fun and it has to do with doing tax-deferred exchanges. But here's where the case has application beyond that. The court in this case ruled that the terms of the agency relationship, what the broker is responsible for doing on behalf of a client, can be modified and is defined in the listing agreement. So as a real estate broker, you can limit the potential exposure that you have by limiting the things you are responsible for doing in your listing agreement. There are all kinds of trade associations that publish listing agreements. What you ought to do is look carefully at what is in that listing agreement and see if there's not an opportunity for you to further limit your obligations to a client. You can't exculpate yourself from any potential liability. That's against public policy. But you can limit the kinds of things that you can get exposed to later if you're careful about how you do it in the first place.